that sounded routine and unnecessary initially. It was to the effect that all judges were thenceforth to be provided with armed security for their protection. Since the judges already had security protection of some sort, the announcement made little impression on the general population and lawyers. Not even the most skeptical suspected that behind the news item was a repugnant episode being played out, the horrible full details of which were to unfold later. Soon it was announced officially that 3 High Court judges and a retired army officer had been abducted at night during the curfew hours of 30th June 1982. Prayers were offered for their safety. But the nation's worst fears became a reality when it was announced that Mr. Justice Fred Pokusakode, Mrs. Justice Cecilia Quanton Abel, and Mr. Justice Kojo Ejei Ejapon, all judges of the High Court, and Major Akwa, a retired army officer, had been most brutally and savagely murdered on the night of their abduction. This cruel, savage, and heartless act occurred at the Bundasi military range in the Accra Plains. The bodies of these precious Ghanaians had been soaked with petrol and set on fire. Divine intervention in the form of a heavy downpour that night quenched their burning bodies. When discovered, the charred remains had deteriorated into a state of decomposition. The nation was stunned. There was swift, widespread and open condemnation by Ghanaians of all walks of life. Pressure mounted on the then military government for a thorough investigation and punishment on the perpetrators. The Provisional National Defense Council, publicly declaring itself to be horrified by the crime and yielding to the strong public pressure, appointed a special investigation board with the former Chief Justice of Ghana, the late Mr. Justice Samuel Azukra, as chairman, to investigate the murders. The courage and professional expertise of its main investigator, the late Chief Superintendent Jacob Jebuni Yidana, an officer of the Ghana Police Service, will go down the history of Ghana as the qualities that helped produce one of the best criminal investigations ever undertaken in this country. The Special Investigation Board submitted a report, which was published along with the government white paper. The Special Investigation Board made a number of findings, leading to the prosecution of Joachim Amatekwe, a member of the PNDC, Lance Corporal Samuel Amedeka and Michael Senyan, and 2 ex-soldiers, Johnny Jandu and Tony Teko. During the trial, Lance Corporal Amedeka, Jandu and Teko escaped in a jailbreak. Amedeka fled the country, but Jandu and Teko were captured and they rejoined the trial. All accused persons were found guilty and sentenced to death. Lance Corporal Amedeka was sentenced in absentia. Though Lieutenant Colonel Teko was also convicted, Lance Corporal Teko was also convicted. He was not available to face the death penalty because it was alleged that some days before his trial concluded, another public tribunal had found him guilty of acts committed in connection with the jailbreak, and he had suffered death in the execution of the sentence of that tribunal. This is a brief resume of the historical background to the dreadful events we have met here today to commemorate. Our departed colleagues died in the line of duty and service to their nation, to their countrymen, and to the rule of law. In response to the call for reconciliation by the National Reconciliation Commission and the biblical injunction that we should forgive those who trespass against us, we have forgiven the wrongdoers for their cowardly and evil deeds. But we still remember these martyrs of the rule of law and will continue to celebrate them. The bar and bench acknowledge and proclaim those good qualities and deeds for which they were murdered. Justices Fred Pokusakode, Cecilia Quanton and Kojo Ejei Ejapon. The bar, bench, and the people of Ghana salute you. You died in the line of duty. You performed your duty as judges without fear or favor. You stood for the rule of law but your assassins hated what you stood for and murdered you. They could not eliminate what you stood for. Your monument stands in the forecourt of the Supreme Court building, in constant reminder of the good qualities required of a judge. Judges, magistrates, and lawyers will continue to draw inspiration from the bold and courageous manner in which you administer justice in those challenging times. We will continue to celebrate you lest we forget what you lived and died for. So, it is with mixed emotions for me to stand before you this morning. It is mixed for obvious reasons, as many a person present to relate to. While it is good to be in the company of some of the illustrious men and women that this great nation has to offer, the essence of this gathering and its embodiment make it sober, such that smothered beneath all the extent of pleasantries lie tinges of sorrow and pain, even if a little subdued with the passage of time. It is said that time flies. Of course, it does, even if winds are not to be seen. For it seems like yesterday when we gathered to mark another Martyrs' Day last year. It is a day that has been religiously observed to observe and commemorate the bestial and gruesome murder of 3 High Court judges, together with a retired military officer. Without any doubt, that incident has become a black spot and a blot on the conscience of this country. But we dare not forget the reason why we have gathered here. For the past 40 years, the bar and bench and other well-meaning Ghanaians have consistently and solemnly mourned the death of these martyrs of the rule of law. We do not only remember the enormous services and sacrifice of the slain as martyrs of the rule of law, but we recognize and honor the brave men and women of the present-day judiciary who continue to discharge their functions of their constitutional office with dedication, resourcefulness, and integrity across the country. However, while we commemorate their martyrdom, I believe a day like this has also another significance which should not be lost on us. Not by any means. It is about the useful lessons that must be learned from the events of 30th June 1982. Short of that, their deaths will not only have been in vain, but it may not be too long when another scenario rests up its ugly head and come upon us. The available facts and commentary about the events of 30th June 1982, in terms of antecedents and aftermath, do not only reveal men and actors who were cowards, but men and actors who were ignorant of the role and functions of the judiciary and judges within our national governance, architecture, and statehood. Yet still, they revealed men and actors of the military regime who were consumed with prejudice and intolerance for the judiciary and its rule, as well as the extent of the personal responsibility of judges in judicial outcomes. They could not draw the line between a judge as a person and his judgments or decisions in the exercise of his judicial functions. Perhaps it can be argued that if the actors and perpetrators of the dastardly acts of 30th June 1982 had had some more knowledge and understanding about the workings of the courts and judges, had been a little bit tolerant, and had exercised a little more restraint, the events of that day and national infamy will have been avoided. In my estimation, it is important that as a people, we try as much as possible to distinguish between and separate judges from their judgments. That is the boundary between fair and founded criticisms and unwarranted personal attacks on judges. The two should not be mixed. I believe it is a proposition familiar to all lawyers that judgments and decisions of our courts or judges can be questioned, scrutinized, debated, and criticized, albeit within the bounds of law, decency, and reasoning and scholarship. That is how the law has been nurtured and developed over time. I hold the view that decent, fair, legitimate, healthy, responsible, and evidence-based criticism of judgments are critical in achieving and ensuring judicial accountability. Of course, our judges do not perform their constitutional functions in a social void. I have no doubt that our judges think that they are, and the work they do are above reproach. They cannot be humans and be infallible. Lord Daniel had this to say. Let me say at once that we will never use this jurisdiction to uphold our own dignity. That must rest on surer foundations. Nor will we use it to suppress those who speak against us. We do not fear criticisms, nor do resent it, for there is something far more important at stake. It is no less than freedom of speech itself. It is the right of everyone in Parliament, out of it, in the press, or over the broadcast to make fair comment, even outspoken comment, on matters of public interest. All that we ask is that those who criticize us should remember that from the nature of our duties, we cannot reply to their criticism. We cannot enter into the public controversy. We must rely on our conduct itself to be its own vindication. Lord Atkins also said, justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken comments of the ordinary men. However, in recent times, there appears to have been an upsurge in the attacks and criticism of judges in their personal capacity, especially in cases that have political undertones and ramifications that invariably generate reasonable and understandable controversies. Our traditional media outlets and social media platforms are inundated with discussions and commentaries whose very import are upon deeper inspection, essentially to denigrate, scurrilously abuse, impute improper and political motives to judges without any basis and only meant to attack and embarrass judges in their personal capacities and to ridicule the judiciary without proffering any sound and superior arguments to the contrary. Some will even criticize and attack judges for their judgments and decisions in the media, when most of the time you can be sure they have not read nor familiarized themselves with the actual judgments in terms of the specific findings of fact from which the decisions were arrived at and are the reasoning that underpin them. It is more scandalous and disturbing when they are done by persons with legal backgrounds who are conversant with their remedies and options under the law if they disagreed with a decision. Ours is an adversarial system of adjudication. The effect is that a judge is invariably required to make the choice between the two parties or competing facts before him. Put differently, almost every decision will produce winners and losers. Naturally, while some will be happy with the outcome, others will be upset thereby. It is my respectful view that while no judgment or decision from our courts may be sacrosanct and must admit to reasonable, legitimate, and decent criticisms, that must not extend to undue, unsavory, ad hominem attacks on the person of the judges who delivered or gave the judgments or decisions, especially when there is no credible evidence of impropriety and corruption against them. For just because you do not like a decision or judgment delivered by a judge, especially because it is politically inconvenient, does not mean that the judge was wrong or that the judge has acted improperly. The courts and judges give decisions on what the law is and not based on how a party or even some section of the people like it to be. We must have and build the culture of decency, of attacking the message rather than the messenger. The danger of not doing so is that unbridled and baseless public criticisms and personal attacks of judges unnecessary cause public disaffection for and suspicion of the judiciary, thereby undermining or even eroding public confidence in the judiciary, what would have a destructive consequences for the administration of justice. Hiding behind political interest to only ridicule and politicize judgments, but not from the angle of legal, scholarly, and constitutional appraisal of their decisions, unfairly and inappropriately lowers the dignity of our courts and hurt the rule of law. That is why it is totally unacceptable for a member of the leadership of the minority in Parliament, hiding ostensibly under the protection of parliamentary immunity granted by the 1992 Constitution, in supporting a motion solely to unanimously approve the nomination of the current Chief Justice, to launch an unwarranted attack on the person of the immediate Chief Justice, describing such a colossus of a jurist in derogatory terms, to wit, under the reign of the outgoing Chief Justice, the level of miscarriage in this country reached a crescendo and must never repeat it. And the former Chief Justice must know when he goes home This miscarriage of justice rests on his chest. In the highly volatile partisan environment we unfortunately find ourselves, such a statement was unfortunate and grossly irresponsible, and it caused consternation among the rank and file of the GBA, especially when the author of the accusations failed to give particulars of the specific cases or decisions by the immediate past Chief Justice that occasioned the miscarriage of justice, and by what scientific tools he used to measure the level of miscarriage of justice under Chief Justice in India. I am certain that the soldiers who carried out the gruesome murder of the martyrs we celebrate today might not have read any of their judgments, yet persons who were relatively better educated and informed were able to indoctrinate and had them to believe that the judgments of the martyrs were in some way detrimental and inimical to their self-interest to warrant such heinous acts. I urge as a people, we learn to be circumspect both in our actions and statements to ensure that no judge in this country should ever suffer the tragedy and fate of the martyrs we celebrate today. The GBA accordingly condemns in no uncertain terms pronouncements and commentaries that tend to intimidate, threaten, and attack the person of our judges over their judgments and rulings by persons who feel aggrieved by or unsatisfied with such judgments and rulings. Such attacks are a direct affront on judicial independence and rule of law and must be denounced unreservedly by all well-meaning Ghanaians. Having no place in any modern and civilized society, I submit that no judge should feel threatened in the performance of the functions of their judicial office. So, in the end, it does not matter who the attacker or speaker is, whether the youth or the age. It does not matter the medium or place from which the attacker or speaker stands or sits to launch the attacks or vitriol, whether from the street or from social media platforms or on radio or even on the floor of Parliament with all the guarantee and protection of privileges. It still does not matter whether the one attacked is a district magistrate or a justice of the Supreme Court, or even a Chief Justice. The value is the same. They are all untidy, irresponsible, reprehensible, and have no place in any decent and democratic society. The judicial office is, and could be especially difficult and a taxing one that involves a lot of sacrifices. It is why it becomes a very difficult decision for some lawyers to leave the bar for the bench. It can be a lonely place to be end up getting personally insulted and publicly vilified only for your decisions and nothing more can be depressing. It is still unacceptable and obnoxious for the person and reputation of a judge to be attacked and disrespected and impugned only on grounds of disagreement with and dissatisfaction for his judgment or decisions delivered within the remit of his judicial office. The GBA will urge our judges not to be deterred or to be covered by these attacks and threats. The GBA assures our judges of our unflinching solidarity and enduring respect. They must remain absolutely resolute and fearless in the discharge of their judicial oath, doing justice to all manner of persons without fear or favor, or affection or ill will, and with integrity and professionalism. At the other end of the spectrum, the GBA respectfully wishes to remind our judges at all the court levels that they, like Caesar's wife, must be above suspicion or reproach. Inasmuch as the GBA will continue to advocate for and defend the dignity, integrity, and independence of the judiciary, we implore our judges to endeavor to eschew all acts of impropriety, biases, improper influences, but work in fidelity to the judicial oath of doing justice to all manner of persons without fear or favor or affection or ill will. The GBA calls on Ghanaians to strive to be more resolute and fearless and vocal in defending the rule of law and the independence of the judiciary and the dignity of our judges as they are a sine qua non in ensuring stable and effective constitutional order. It will ensure social and political stability in Ghana, necessary for our economic well-being and development, through the guarantee of effective accountability of other state institutions and actors of the realm. At least, when the chips are down, especially from the excesses of the two other arms of government, and we are at our wits' end and helpless, it is the judiciary that will be our succor and hope. We do not cut our noses to spite our faces. When it is looked at carefully, it will be seen that the judiciary is and remains the most veritable guardian of our constitutional rights, irrespective of the social, political, and religious device we belong to. The better choice is therefore for all of us to help to improve it and to better serve it and not to attack it and tear it down. May the events of 30th June 1982 never happen again. Let us use this day to remember and reflect on the heinous crimes perpetrated on 30th June 1982, the lives that were brutally cut short and their impact on the families involved. Let us as a people resolve to pursue and sustain a path of peace, love for one another, mutual respect and tolerance for one another, and eschew all acts of violence and lawlessness. We would have done enough to avert another 30th June 1982. May the rule of law reign supreme in our land. May God bless the administration of justice in our country. May God bless the Ghana Bar Association. May God bless our law enforcement and security agencies. And may God bless our homeland